Ladies and gentlemen, I'm Khaled and I will be your host for the session. Good evening and welcome to our webinar, IP Issues in Digital Media. The session will be presented by Gowree, Gokhale, Ranjana Adhikari, Aarushi Jain and Siddhartha Sarangal. Please note that this session will be in listen for about 60 minutes, of which first 30 to 40 minutes will be spent on panel discussion and the remaining time will be available for Q&A. Requesting all the participants to be on the mute mode. You can post your questions in the chat window while the panel discussion is on. The moderator will queue up the questions for the speakers accordingly. Should you need any assistance during the conference call, you can use the chat option. Do note that this conference is now being recorded. I now welcome our session presenter, Gowree Gokhale, who co-heads our TMT practice. Ranjana Adhikari, co-head of Media and Entertainment practice. Aarushi Jain, of Media and Entertainment practice. Siddhartha Sarangal, member of our TMT practice, practicing from our Palo Alto office. All participants are requested to be on mute mode. Over to you, Gowree.
Actually, thanks, Khaled, and I would do the honors of taking that over for Gowree, and I'll give her some much-deserved break for this session to be the speaker, and I'll take on the job of being the moderator. But thanks so much, Khaled, for giving us a very warm, long-titled, proper introduction. But I think it's 9 p.m. A lot of them are actually giving us time from their dinner time away from family. So why don't I introduce them to a fun set of people. We do have another very nice side to us, apart from being just lawyers. And let me introduce all of them through my eyes instead. So first up, Gowree Gokhale. Yes, she's the head of the TMT practice, but I don't know how many of you know that she's also the dancing lawyer, a trained Odissi dancer, and all millennials out there, she's going to give you a run for your money. So beware of that. And then we've got my colleague, Aarushi Jain. Let me tell you this little snippet about her, that she's actually our in-house event planner expert. Nothing fun happens in our organization without her. And she's an integral part of everything, so not just a boring media entertainment lawyer for sure. And Siddharth, of course, I discovered something very interesting today, that he's not just an avid rock person who loves it, but he's actually looks into the socio-political side of rock music. He's probably the only person in this world that I know who does that. Well, interesting nevertheless. And for me, I'm just an accidental lawyer, poet by heart, could have been an astronaut, but ended up in Nishith Desai Associates. So that's our story in brief. And we hope to make this as epic as possible for each one of you today. I think it's safe to say 3 things which have been keeping us all going at the time of COVID and lockdown are hand sanitizers, N95 masks, and Netflix / Hotstar / Amazon Primes and every other digital platform out there. So I think as consumers, thank you to each one of them for making this time at home quite bearable for each one of us. Safe to say, I don't really need to say why we're having this session. The importance of it is quite paramount in our lives today. But I think quickly what I could do is just kind of describe how the flow of the session is going to be, so that everyone on this panel, as well as the audience, understands what we're seeking to cover today. Lots of things we'll be talking about, so bear with us. I think we have a very mixed bucket of audience. We've got veterans from the industry, we've got students, we've got our friends from overseas, lawyers, everyone joining us at today's session. So for some of you, a lot of the things that we will talk about, you're already veterans and experts on it. But for the benefit of everybody, we're going to touch upon a wide spectrum of things. A couple of things a little more basic to give context, as well as some of the practical insights that our team has dealt with. So the session would, we'll just basically meander the session. We'll begin with some of the deals that we see on the content licensing and the library content and acquisition side. Then segue into the content development bit of it, where you're really conceptualizing the projects and making the content. And from there, we'll take the discussion to the distribution of the same on the digital platforms, and touch upon a very important aspect from there on, of course, music and royalties, and kind of sum it up with the last but not the least, a very important aspect on piracy, which concerns everybody in the industry today. So that's broadly what we will be covering today. And I think we could safely move into the main part of the session from here. Gowree, you are probably the most experienced amongst all of us in the panels, and I think it would be fit to start with a question for you to begin with. I think, Gowree, when the digital platforms really came into India, we saw a flurry of a lot of content acquisition deals that were happening, of local content, regional content. Some of them were in the form of primarily licensing deals, some also in the form of acquisition deals, depending on the commercials that the parties looked into. Could you, from your experience, tell us some of the very key issues that digital platform players should really keep in mind when they're looking at these kind of licensing and acquisition deals? Over to you, Gowree.
Sure. I was still catching my breath from all the cooking, cleaning, and eating. So thank you for that little introduction. I could catch my breath. Okay, so coming to the licensing and acquisition aspect that you mentioned, Ranjana. So as you rightly said, whenever a platform launches in India, right, they need library immediately, because obviously, by the time they start producing originals, it may take some time. So what we really saw in the initial phase was the either a licensing, which is say a short term, say 5 to 7 year licensing, or say a perpetual, acquisition or a perpetual license. Maybe I can put them in the same bucket. The interesting part in the Indian context was, and this was right in the, at the beginning of the OTT, what we did was, as you may recollect, our team was involved in quite a bit of what we call as a due diligence or a chain of title, right? Because the library content, especially the 70s, 80s, 90s content, when you look at all the production contracts, probably they were almost absent, right? So basically, you go back to the basic concept that the producer is the first owner. So basically, if you're taking from the producer, you should be assured that yes, you're taking from the right title owner. However, that producer would have granted that content to multiple parties, and this is something we had seen even during the broadcasting sector. I remember we did a very interesting case in Singapore, in fact, where there were multiplicity of rights that were created, and then the parties had to figure out various windows and the like. So the most important part at the beginning was to check whether and to what extent the rights have already been given to third parties. Interestingly, in the olden days, when the satellite television acquired the rights, they typically took the entire bucket. So we also had to look into the fact that whether the agreements that were entered into with the licensing, or rather satellite companies, whether those had the digital rights with them, or the producers still held the digital rights. So that's the first issue. Where do the rights vest? The second is, if at all those companies, say satellite companies, had the licensing rights, whether the producer could get back those rights and then pass it on to the OTTs, because satellite companies probably at least 2 years back were not really exploiting those rights. So that was the one issue. The second issue, more from a chain of title perspective, is whether, especially in the acquisition scheme of things, where suppose a title is under production, and you want to go and acquire that title, say for the digital platform, there also, how do you slice the IP? How do you do the windows? I think Aarushi will deal with probably those aspects in more detail. But even then, the question was that whether the acquisition is, for only in Indian context, it becomes very relevant. I'll give you an example also, that suppose, am I taking the rights only for Hindi language? If it's a Hindi film, do I have the subtitling rights? Do I have the dubbing rights? Because if I'm going to, and if that producer did not have a right to make a dubbed or a, or a, another language version, can I do that or not? So these are some of the key issues, going back to the point of due diligence, because it becomes a primary importance because what we have seen in the Indian context that parties were not that savvy, especially for the library content. They were not that savvy to negotiate their earlier contracts, and therefore they may actually slip up by making representation on warranty. So there was always a dispute whether we should go for only reps and warranties and deal with as and when, or do we really need to you do a due diligence. So different companies had different approach for that. And of course, in the digital context, if there is a dispute, it's quite easy to take down the title, right? I mean, honestly. And then in that case, do you really spend that much time, effort, and money on due diligence? Or you just leave it by indemnity, reps, and warranties and just pull down the title so that future damages are controlled, right? So this is all commercial decision, but linked to the IP rights.
Very interesting points that you raised, Gowree. I think this explains largely why we saw a large part of the deals that we did in the beginning to be instead of the producers against the broadcasters, because that's where the rights really were. I think they were bundled up with the satellite rights. Nobody really understood the value of it, many years back, but today we understand the value of it truly. So that's interesting. And I think from there, we can also kind of move on to the next part of this. But I think before we move on to it, something relevant for those of you who not really very conversant with IP or this is new to you. When we're looking at the media entertainment industry, the two primary bodies of law are the Copyright Act and the Trademark Act. So a lot of the part of the discussion today that we'll had will be centered around these two pieces of law. So that's just to give the context to everyone. And of course, Gowree did mention about assignments and licenses there. Again, just a handy note for everyone. Until and unless this is in writing in the Indian law context, it's not a valid assignment or a license for the purposes of the copyright law. So when you're looking at a chain of title documentation, first and foremost, you need to have a document in place, without which there really wouldn't really be, they wouldn't really be the right owner. So keep that in mind going forward. And the third but important aspect also is keep in mind the copyright law has been amended many times over. And when you're looking at library content, which could be really old, one is film content, could be music content as well. Do always bear in mind to check it against the law that was relevant and applicable at a certain point of time, because that could also have kind of an implication on the chain of title diligence that you're looking into. Now, I think it will be a good point to actually move on to the second part of our discussion, which is centered around developing the content. And this is somewhere, Gowree, where I could pick your brain again, perhaps. I think at the heart of any deal or project is always the content in question. The script of either a film, a web series, TV episode, any kind of content, really. The journey usually begins for most entertainment platforms for the scripted content at the script stage, really. Now, when I'm talking about script, I'm talking about, all other kind of literary works really associated with it. Now, we've seen several digital platforms commissioning third-party line producers to shoot their projects. Especially, I think, in the context of a lot of the foreign platforms have come into India, or even the larger platforms in India, they prefer commissioning their projects to line producers. Could you please throw some light on what do digital platforms really need to bear in mind at the time of commissioning these new projects, especially where the script is concerned?
Sure. So, Ranjana, I think I will deal with two specific aspects. One is the nature of deal structure, but also maybe at least apprise the audience about there will be the tax issues that also will have to be taken into account, right? So the first aspect that I will deal with is the deal structure. Now there are two possibilities where somebody approaches you with already developed script, right? So basically there is an existing IP or an idea, may not be fully fleshed out script, could be a story. So there are 3-4 possibilities. One is a story, step outline, fully developed script with dialogues, completely bound script. So depending upon where the how the IP has already been developed, the question arises is whether I as a platform or any acquirer, do I say that okay, I'm directly commissioning you basis this, or do I first acquire that IP? And the reason I want to acquire that IP in advance is because something goes wrong in during the production or otherwise, I maybe have a step up right, in the sense step in right to take over the production, or maybe appoint a third party line producer, right? So what I really want to do in the first first step is to take control of the IP, ideally, rather than simply saying, hey, I like the script, go ahead and come, I commission. Because till such time, though it can be viewed as commissioned, but that point onwards, the commissioning will start. So the question arises, what happens to the point before that? So technically, I need to get that IP. Once I've commissioned, that point onwards, at least from a cinematograph act perspective, cinematograph perspective, under the Copyright Act, it says that once a cinematograph is commissioned, right, then you become the first owner as a producer, unless there is an agreement to the contrary. Going back to the basics. The question really is that, am I really commissioning or not? So the agreement will speak for itself, right? And then you can probably call out, yes, it's a work for hire. And another important thing to remember is not only look at Indian law, because these are acquisitions for global platforms, right? You are going to acquire the IP for the global platform. So you need to keep international standards in mind as well, because in India, for example, we may be calling it commissioning. Some places it is work for hire. So basically keep the drafting broad enough to cover all those elements where the essence is right from the inception, you are the owner. It is not a transfer of IP. So there is a difference between you being the first owner than being transfer of IP. Because as you know, when there is a transfer of IP, there are certain other idiosyncrasies that come in terms of modes, mediums, and this and that and the other. So there can be some technical difference. I'm not getting into too much detail here, but that is one. The second possibility is that I, as a platform or otherwise, I'm myself, my creative team has come up with something, and then I'm appointing writers and all of that, where I'm appointing a writer. That is the second situation where, then again, after I've acquired that IP from the writer, then I appoint somebody for commissioning. The third possibility has done a book option, correct? Then I'm developing the script. So it will depend on whether I decide to directly appoint the writers myself, take control of the IP, and then go to a producer only for production or not. Now, all these elements which I mentioned will also have some tax element. Now, if you are a local producer, or rather a local company tying up with a local company, or a foreign company tying up with an Indian company, so depending upon the IP, so whether it's an acquisition, then when you are paying money, what is the tax impact? When you are doing a commissioned work, then there is a certain provision under the copyright, under the Income Tax Act. When it's a that kind of work definition as has been given under the Income Tax Act, your withholding tax could be only 2%. In some cases, it could be 10%. So what exactly is the nature of the deal? That will depend upon the tax treatment will depend upon that. And we have seen a lot of issues when there is a foreign party commissioning to the Indian party. There are GST, which is the goods and services tax issues, as well as income tax issues. So I'm not getting there in detail, but those have to be kept in mind, right? On the insofar as the documentation is concerned, because your document will speak one language and the tax department will read it in a different manner, it will be a problem. So we always work with our tax team to ensure that the context of the IP licensing, and as you know, IP is very moldable, right? In the sense, or the language is quite moldable the way we want to tweak it, not tax. So from tax perspective, we have to be very clear as to what is the tax interpretation, and then do the documentation accordingly.
Okay, super educative there, Gowree. Thank you so much for that. I think this would be a good time to segue this discussion into another aspect of development of the content. You can never really have content without the talent. But sorry, I think there's another question that I can think of on the script and the theme before we get into the talent aspect. Maybe Aarushi, you can give us some thoughts on this. There are a lot of these themes around the biopics, stories of individuals, stories around live events happening, matters which are sub judice. But there are a lot of privacy rights as well as IP right issues around this. To a platform to make a biopic or any kind of a movie on these kind of themes, is there a specific recommendation you would have in terms of documentation or otherwise?
Thanks, Ranjana. I think biopic is one genre that never really goes out of fashion. No matter what point in time, whether it's the 60s, 70s, or the 2000s, you'll always find, content makers being fascinated by biopics. Now, what exactly are biopics? Simply put, a biopic is content or a film, in whichever format you would want to call it, based on the life story of an individual. Slightly different from the inspired by true events kind of a scenario. Now, since a biopic is based on somebody's life, according to me, it's only fair to take permission from that person before you portray that life on a cellulite, right? Because many aspects of that individual, including some private aspects, are going to be depicted. So, the first thing first is that you need to ensure that you have a proper documentation in place with the individual whose life is going to be projected in the biopic. A lot of times it's done by way of no objection certificates, but nowadays industry has matured, so there are proper contracts. The benefit of this is one, you have a contract in place, but at the same time, a lot of time the individual whose life is being projected also gives valuable inputs about his life story, which makes it more interesting for the viewer because not everything falls part of public domain. Now that's about the individual. But what we also should remember is that when you project a biopic, it's not just the individual who's part of the film. Family members, friends, sometimes even acquaintances, and sometimes even their enemies might be part of the whole picture. So you need to take permissions because individually each of them also have their rights to be their privacy rights, which are now somewhere getting tampered with because their life story is coming on the film. And our courts have held that right to privacy is a fundamental right. So the basic thing first is that you need to take permissions before you put anybody's life story, because just because a person is famous doesn't mean that you can put it out there. A famous person does have the right to decide what, how, and in what which manner it needs to be projected. There is another segue to it, which is basically in the nature of content which is based on lives of historical personalities. For example, you had films like Mangal Pandey. You had films, for example, which were based on the life of Bhagat Singh. Now, it's not the case that this kind of content did not go to court. I mean, when the movies were made, the matters did reach court, and the next of their kin had some issues with respect to the manner in which the life story was being projected. At that point in time, the courts have said that when you're projecting life stories of historical persons, some sort of dramatics is fine. There is something called creative freedom, which can be exercised at the end of the day, but disclaimers therefore work best in such scenario. So to sum it up, you need to have permissions in place because right of a personality right of privacy becomes an important facet of any individual's right that needs to be respected. Documentation needs to be clear with requisite permissions in place, as well as when you're projecting it, the disclaimers, legally drafted, easily readable disclaimers become important when the content is projected. There's another genre of this kind of content which is picking up, which is based on some real life events. For example, some accidents or some tragic event, maybe even murders. Now, one such example, I won't get into it too much in detail, but probably spend 30 seconds on it. One such example was a couple of months ago. There was a murder which was highly, publicized in the media. A woman who killed a couple of her family members, or allegedly killed a couple of her family members, and there were producers who wanted to make content based on that life story. Now, even in this case, the family members did move the court to say that their right to life, their right to peacefully live, was kind of getting infringed and violated, and such kind of content should not go up. So, from a platform perspective, they need to be sure of what is the back to back, what is the real content that they are taking and how it's being projected. That becomes important.
I know who I'm going to have on speed dial in case someone wants to make a biopic for me. So, Aarushi, you have all rights to represent me. But that was on a lighter note. But I think, Aarushi, it's fair to summarize it by saying that it's not really an IP, right? But it's something which stems from, of course, right to privacy, personality rights that you also highlighted, and probably the right thing to do is to take these permissions and consents also from the perspective of avoiding ensuing litigation. And we all know how most movies, films, etc., are always plagued by litigation right before the release.
Absolutely correct, Ranjana, because these are precautionary measures that as content owners and content projectors one take. There is no requirement under law as such, but these are good to have practices which are documented legally.
Great. Okay. And I think it's also fair to say that the information that's available in the public domain, in terms of, let's say, the events which are happening, that's fairly accessible to use, and that's not really probably an infringement of right to privacy to say that, because it's out there in the public domain, but there might be certain facets which can overlap with that right. And again, going back to the point of trying to avoid litigation, the most sensible approach would always be to take these permissions. But having said that, if probably there are times when platforms or content makers don't have that kind of wherewithal to reach the correct parties to take that kind of permission. In that case, it may not be purely illegal, but yes, you do have the risk of having some litigation. Now that we're talking about individuals, right time to segue the discussion to the talent and artists. And perhaps Aarushi, again, I can pick your brains over here. Could you probably tell us? I know that you've been doing a lot of work on the artist and individual side. For a lot of the platforms who are making this kind of content, could you give us some key points that a production house would need to keep in mind while engaging the talent and crew in general?
Yeah, sure. I think before that, Ranjana, I did see a couple of questions that popped up on the previous one. It will be probably prudent to just quickly answer those questions. So I'm going to, take that liberty to do so. I think one question was about, if the information is available in public domain, then do we still need life rights? I think you kind of summarized it here. If the information is in public domain, there is no real requirement legally to go and take these permission. It's a good to do, and then there are some do's and don'ts about how you end up projecting such content, because at the end of the day, hurting somebody's feelings, hurting or bringing somebody's or distorting somebody's life is not what the intention should be. And with respect to certain murder cases that are translated into films, where to the extent where the case is completed, there's a judgment out, well, you can definitely put your view out there. But a lot of times what happens is nobody waits for the final judgment to come out. It does take some time in India. So if you're doing any kind of content based programming on a content which is a real life event, make sure that we are not kind of prejudicing justice or interfering with the justice system, because sometimes the way expression of views happen can also become kind of an issue. So with that, I think I'll move on to the question that you specifically asked me, Ranjana, with respect to the kind of agreements or contracts that one looks at with talent. Now, like Gowree was saying in the initial part of her speech, right? When a platform onboards content, whether by way of a licensing deal or an acquisition sort of a deal, they rely on the producer to give them a gamut of rights. These rights are documented in the agreement between the platform and the producer. But the producer also derives these rights back to back from various talent. Now, this talent would be your directors, maybe your executive producers. You also have the lead cast and crew, right? So these are the individuals who are playing the front role. But other than that, you have owners of underlying rights. You have your lyricists, you have your writers, and other cast and crew. Now, each of them enter into agreements. Take, for example, if the producer was to give a representation to say that, all the IP that is as part of the work that is assigned in favor of the platform or is licensed in favor of the platform, it will become an issue if the producer does not have back-to-back contracts in place. That emphasizes the need to have back-to-back contracts. And typically, the main clauses from the contract between the producer and platform are also duplicated as we go down the chain. That's kind of a good practice that now the industry has been following, so that we have clarity and handle over the rights. Let's look at some specific examples. With respect to underlying works, lyricists, musicians, etc., there is an issue on the royalty side, which is something we'll deal with later. But when we look at, for example, an artist, a lead actor, for example, the contracts with the actors typically have IP assignment rights. Now, one is the actor is contributing to, the script development process. It can even happen when the actor is on the set, giving valuable inputs on a day-to-day basis, in which case your IP right, basically your IP assignment clause can be broadly worded. But there are some cases where the actor is merely a performer. What we need to understand is that a performer has certain specific rights called the performer's right under the Indian Copyright Act. So this is the right that needs to get assigned, which basically gives the producer the right to, reproduce the work, broadcast the work, etc., which also comes along with certain moral rights attached to the performer's right. If this distinction is made, contracts negotiation sometimes gets easy. The other point is that, nowadays, a lot of artists, and this has been a practice internationally, but nowadays, even in India, a lot of artists are using their own entities to route their contracts rather than directly contracting. So in this case, transfer of rights from the artist to the entity to the production becomes a very important, chain of title issue. So this is the concept of loan out entities. So this is, I think, we have many other questions to deal with. We can, keep discussing about this issue for the longest time and never end. But to summarize, these are some key points one keeps in mind in back-to-back contracts.
I think I'm just going to take 10 seconds here. I think there are a couple of things popping up from the audience on the window to us. So I just like to clarify for the benefit of everybody on this call. The reason why we're talking a lot on the agreement side of things is because a lot of the IP issues go into the heart of contract and contract drafting, really. When we talk about intellectual property, as I mentioned earlier in this session, we really are talking about copyright and we're talking about trademark. Now, the heart of every IP issue today that that we really encounter for digital media platforms, a part of it really stems from what kind of deals are being struck today. So, for example, Gowree covered early on the licensing part of it, the assignment part of it. From there, our conversation has segued into the content development part of it, where the first segment, of course, was on script. We've just touched upon an equally important part on the talent part of it. And we just had a discussion on performers' rights, which is a very integral part of, again, the Copyright Act, a very important intellectual property right itself. And from there, correct time to move on to you, Siddharth, where we're going to touch on the third very important element of the titles of the films. So could you help us and the audience today to understand if there's any way of protecting our rights in the titles? And in fact, is there any intellectual property at all in these kind of titles? What should really one look at for protecting it? Over to you, Siddharth.
Sure. Thank you. Yes, the short answer is yes, there is intellectual property that you can use to protect titles of films. So the title of a film is one of the really key assets of the IP that you want to protect. Before we move on to the legal aspects of this, let's talk a little bit about like the industry practice. Now, the Indian film industry has sort of adopted what happens in Hollywood, where the industry associations, for example, the Indian Motion Picture Producers Association, or for example, the Association of Motion Pictures and Television Program Producers, these associations run registrations where you can sort of, when you come up with a title, you can go and register the title with them. This is really an industry practice. It does not have any legal sanctity, but when you want to establish later on that whoever came up with the title first, it's useful, and courts might look at it and consider this registration to determine who was the first adopter, the first user of this title. Now, moving on to the legal aspects, really the key protection in terms of protecting a title of the film is under trademark law. And you can either protect a series of film titles, or you can protect also single titles in a film. Now, in order to protect single film titles, what really needs to be proved is that the title over time has acquired a wide reputation among the public and the industry, and that it has also acquired a secondary meaning. Now, how do you establish this? This is done by sort of trying to associate the title of the film with certain production houses, with certain directors. This is how they sort of acquire a wider reputation among the audience, right? Like people, for example, people really know what pictures are made by Yash Raj Films, right? and these sort of things over time gain reputation. What you would do in these situations is that you would sort of try to establish that, well, this is how much money people have spent, how long the title has been in the public, how much money has been spent on advertising, how widely known the title of the film is. So these are sort of factors that go into determining and ascertaining how much reputation and how much secondary meaning the title has acquired. You know, try to associate it with production houses or with certain actors or with certain directors. It's much easier for a series of films because once you've established it for a single film and that reputation is already established, each subsequent series of films becomes easier to sort of protect under trademark. Now, when you want to consider, when the courts will sort of look at what factors go into whether the film title has acquired secondary meaning, they will look at the duration and continuity of the use. They will look at the number of people who thought or viewed the work, how close the title of the film is to the geographical and product market where you're seeking to protect this title.
Sure. Thanks so much, Siddharth. That's extremely helpful. And that was a bit on the trademark law and how that has an impact on the movie development part as well. I think let's just move on a little bit to the next aspect, which is distribution of the content on the digital platforms. Again, we'll be talking about the kind of IP versus contracts and the issues that we look at again over here. So perhaps I'm going to make this question two-way, part to Aarushi and part to Gowree as well. So maybe Aarushi, I can begin with you again. I think, like, you know, from Gowree's earlier response, we heard that over a period of time, we've really begun to realize the potential for digital rights. We've seen a complete sea change in the kind of commercial rights that we have to negotiate in terms of IP. Now, what would be really interesting, I'm sure, for this audience would be to hear our combined experience in this regard. So maybe if you could throw some light on the unique IP rights and commercial points that we've experienced in terms of negotiations in these kind of contracts, and what should you really look at to protect your IP licenses/rights in this case?
Thanks, Ranjana. And I think this is an answer that you, me, and Gowree will collectively aim to answer. I'm pretty sure there could be sessions and sessions debating about this issue, but let's get to the point first. Now, when we talk about rights, right, with the advent of this whole digital media industry, the nature of rights have become, manifold, and the industry has also moved beyond to crystallize these rights. At one point in time, we would have contracts that say that, I'm hereby assigning all my copyrights in this work to you. That's no longer the case. We have different modes and media of exploitation, right? For example, just to take an example, if you have a script, a story, you could convert it into a film for cinematographic purpose, but that film can go onto your cinemas first. It can do a television premiere first. It can even do a digital premiere first. And nowadays, you see the growing trend where there are so many films which are directly released on some of the digital platforms because of the nature of consumption they have. So what comes along with this? I think what is important for us to appreciate that, there are different kinds of technologies that are used by digital platforms. There are different facets of rights. Digital rights is a very broad term here, but at the end of the day, you have T words, you have A word, you have S word, different kind of transaction rights that happen. And with each kind of platform and the manner in which the platform functions, the nature of rights and the gamut of rights also change. So let's put it, simply. For example, I have a film. If I want to sell it on a digital platform, I may decide to sell it to maybe a T-word platform. I may not decide to, give them the rights for a similar kind of a product for my film on a different kind of service, say a S-word service that they operate. So the diversification of rights, the windows, the holdbacks are really now playing up because each right is worth monetary consideration as well as projects to a different audience altogether. And I know Ranjana, maybe you'll discuss a little bit about window and holdback concepts that I just spoke about, but I also want to point out here more from a drafting point of view in the digital era that we are now living in. Articulation of rights has become very important. Very recently, we had this case in the Bombay High Court where a film right was being assigned for X purpose, right? And the court interpreted the contract to say sequel rights were not assigned because the contract did not even mention the word sequel. Now this becomes important from a digital industry because we are all used to this concept of season 1, season 2, sequels, prequels, etc. So from a long-term perspective in the digital media space at least, you need to make sure that your rights are getting very, very clearly articulated. Otherwise, you probably don't even have those rights.
Let me add quickly a couple of points here, especially when we spoke about the technology, right? And I think I saw on a couple of questions that we are talking about the digital platform. And here let us understand when we started with this, right? The definition of the term internet itself was a question mark. What do you mean by internet? Right now, that so we had to actually arrive at definitions, looking at international definitions, ITU definition and the like, right? So that was the first. The second issue arises is whether IPTV, which was really in the Indian context more like a closed loop kind of a TV where which is a licensed TV, right? Which is a licensed activity by the Ministry of Information and Broadcasting. So whether when you say internet, does IPTV fall within that or does not? That was another question that came up, right? And whether you need to specifically call it out as a part of this or it is not. Do you include closed loop? Now, when I say closed loop, that means or closed user group, right? So that means it is not a open internet, but it's only a system where only the subscription members are allowed the entry and not everybody in the open, right? So some of these tricky issues, unless you understand what we realized, and we were lucky enough that we have people who understand the technology in depth to be able to appreciate these differences and articulate and define them in a manner where the client's interest is best protected, right? Because those are the tricky ones. The other interesting thing in the Indian context, which not many people realize, is the foreign direct investment policy. Now, when you talk about SWOT, which is streaming, right? It's a service. When it's a service, when there is no download, correct? You're simply streaming. In that case, you're not allowing. I'm not talking about temporary download here. Let me just clarify. I'm talking about permanent download. When it's a permanent download, it could be viewed as the fact that it is and it's a delivery of a good, correct? And then will it amount to retail trading? If it is retail trading, then if there is an entity which is a foreign, which has an FDI, technically, can it actually carry out that retail trading activity? So these issues were coming up, right from the days. If you remember, we had this, what is it called? There was a satellite radio world, what was it? I forget the name, but when the satellite radio, World Space, yes. So satellite radio, during those days also, I do remember that FIPB had raised an issue whether they are carrying out a retail activity, and that time it had to be explained that it's a streaming or rather it's a radio. There is no download or there is no delivery. So when you're doing the contracts also, if you're viewed to have taken that right, and if you're an FDI entity, can you even take that right so that you may not be carrying that activity, but whether it will create an issue for you? So some of these nuances are not quickly understood, and then those have to be pointed out or flagged out when we are doing these type of deals. The other aspect, which I just quickly, I know I'm conscious of the time here, but the other aspect is, when we are defining, for example, simultaneously when all these people started coming in, we also had DTH platforms also doing pay-per-view and those type of deals. So how does it work out whether that falls within the definition of of the internet or that is not? So that was a technical issue also that was being debated. I'm not giving all the answers here. Let's keep something in our bag, but these are the issues that are coming up and have been coming up. So therefore, in the digital scheme of things, all these nuances have to be understood and definitions articulated and exclusions also articulated very well.
Very extremely insightful. I'd like to take a moment to just go back to the discussion that Aarushi began with on the contract and what we put in. I think there are some other relevant aspects which go hand in hand, somewhere partly commercial, partly IP, but it's very relevant in the digital platform context. So when we're talking about, current kind of deals that we're looking at, and for the benefit of everyone, when we refer to an SVOD platform, it's really the subscription video on demand service platform. Best examples would be like a Netflix, for example, and similar genre. So, when the platforms came in, they were looking at having exclusive rights for a lot of this content. Now, how do you truly protect commercially as well the exclusivity of the right? We just heard Gowree and Aarushi point out that when you're looking at technology, the IP right vis-a-vis technology can be broken down into so many varied forms. Whether you're talking about IPTV, you're talking about DTH, you're talking about a T word, F word, A word. There's so many different ways of breaking down the same right. But at the end of the day, what's the consumer experience? And the commercial guys would typically put that lens to look at it, and then they bring in the concept of what we call as a holdback. Now, obviously, your content licensor and the slash content owner has the IP right for all those other rights not exclusively being given to the platform. On most occasions, you ought to, and you would find negotiation positions where you would have holdbacks in the form of all these other kind of rights which could equally be given on the platform. So say, for example, if you're taking an exclusive SVOD right for your platform, you may want to consider having holdbacks for the same license period for a free video on demand service, an advertising enabled video on demand service, or even an electronic sell-through, which is called as an EST right or a TVOD right, typical holdbacks that would come in for the license period. Now, equally, the other part comes on the promotions bit of it. Arshi mentioned earlier about, in India, you typically have a theatrical release and then you go on to release on either of a satellite or an internet platform. Now, depending on which window you're really going to have your release in right after the theatrical release, you would also want to negotiate the window for promoting as well. And typically it will begin prior to your license period beginning, but well after the theatrical releases. But that's another part which helps in safeguarding your actual exclusive IP right as such. Equally, I think hand in hand for the digital platforms, you also need to ensure that you specifically articulate the right to dub, which languages, which rights you have in terms of subtitling, and a lot of these similar kind of rights, which unless not articulated specifically, it will probably be deemed that you don't have it as a part of your license. So that's some food for thought for the digital platforms on the kind of documents you could look at. I'm going to very quickly move on to the next part of the discussion. Extremely embroiled in a lot of controversies, music rights, extremely difficult to understand. So I'm going to point out to our in-house expert, Gowree. I think this one is something where you could lead us on. So there's been so much ado about music royalty, especially post the 2012 amendments. Some of the questions also that have been popping up on the screen are regarding this. Perhaps one of the most complicated worded clauses in any contracts today that we spend our energy negotiating on are those. Could you explain for us, one, what the real issue is, and two, how are the platforms specially addressing them in contracts today?
Ranjana, I rather not answer that question.
I will do this. I will give the liberty because it's just 10 minutes. I'm going to give the liberty to cherry pick the best parts of my question and answer whatever you feel like.
Right, I think as you rightly said, and this is an often conversation when we are talking to the deal teams, negotiating contracts. When we talk to them, and some music clauses come up, they said, no, that is something handled by our music team. We don't want to even look at them, right? So even within the companies, you will find that people who are not dealing with music do not want to deal with music, right? So we are unfortunately in a situation, and after the 2000, whether it is before 2012 or after 2012, I think the unfortunate part here, and I will not fully answer your question, but I'm just going to tell the issues here. The unfortunate part is, the 2012 amendment has created quite a few interpretational issues, right? And the most important interpretational issue which has still not been addressed is whether when a sound recording is being played, whether the underlying rights are also being exploited or not. Now that litigation is pending before the Bombay High Court, and why does it become relevant is because if the underlying rights are not viewed to be exploited when the sound recording gets exploited, is that then there is no entitlement for royalty, right? So that is one of the issues pending before the Bombay High Court. And after Aditya Pandey case, probably the pre 2012, we can say that okay, there is some uh, kind of an understanding. Okay, pre 2012, maybe the situation was different, but so that is one issue. The second issue arises is who bears the royalty. Now this becomes more like a commercial issue. That who bears, if at all the royalty is payable, and there are two different things, right? One is the originals. When you yourself are creating content, the situation is different, of course. But when you are acquiring content, the situation is different. I'm saying situation is different more from a commercial point of view. So some people take a view, and international more so, some people take a view that internationally we in any case discharge that liability, that treat is more like a cost to the entire thing, and just pay up and sign up with the relevant societies. Or some take a view that no, we will want the producers to clear those rights and we are not going to pay any additional funds for that, right? So that becomes more of a commercial point. The other issue that is coming up is the Singers Society. Now the Singers Copyright Society has also been formed, and they have ISRA. They have started claiming rights and royalties because they are saying we are the performers, and with the combined reading of the amendments made to the performers right along with the other the copyright provisions, with the combined reading, they have begun to stake their claim also for royalty. Now that is another litigation pending before the Delhi High Court, where similar issues are being raised, that whether singers should or should not be entitled to that royalty, right? So that's the second issue, or other third, fourth, fifth, whichever issue, right? The other issue that is coming up is the whether the performers themselves, because if you see the performers related provisions also have somewhere talked about the commercial right. There have been some amount of discussions whether the performers, non-singer performers, whether they should be also allowed to claim some royalty, right? So therefore today the situation is that nobody knows the answer, how it's going to pan out of all these cases. So parties really end up doing a commercial negotiation to say that if this happens, then this is the liability. If that happens, then that is the liability. And each company would take a different approach towards that, in sort of, bifurcating the liabilities, right? So what is a statutory payout and what is a contractual payout? That also bifurcation is being made. I know it's a very convoluted answer that I have given, but the situation is convoluted. So there is no clear answer today. It is a commercial negotiation between the parties, and each one basically will have to ascertain what are the likely sort of commercial liabilities that are likely to come in the future and make provisions for that.
I think calling it convoluted is actually giving it a compliment, Gowree, in the current situation, because we know how complicated it really is. And I must compliment you. You have summarized in 4 minutes the most complex issue that we've dealt with in the last 8 years now. So that's great. I think the struggle that platforms always have is, do you need to go for the rights, for just the sound recording rights? Do you need to go for the underlying rights? Who do you pay royalties to? What's the percentage? I don't think any of us really have a concrete answer, except how we like to interpret the law. So let's live with that for the moment. I'm conscious we have exactly 5 minutes, but I did promise the audience that maybe we could spend maybe a minute or two in just describing what the piracy initiatives have been. Gowree, I know you've been involved in a couple of them. Maybe one or two of the top highlights to just give things a very positive note for this session, of course.
Sure. So I think piracy, has been an issue now. of course, right, from the olden days, right from the theatrical only rights, where there was camcording, that was being undertaken, to the television, when you saw people recording again from television or the video cassettes, etc., right, and then circulating that. So we have had these issues in the digital context. It becomes probably slightly easier for people to sort of copy, probably, and then and then people losing the revenues, of course, because of that. So quite a few industry initiatives have been taken. One of them being very interesting case that was filed in the Delhi High Court. I call it a hydra-headed, injunction case, and that's what the judges said that, because what happens is when you try to block one website, okay, or a portal, the other pops up with the other URL, correct? So what the Delhi High Court said was that because of the unique nature in which this particular website keeps popping up, they gave a very interesting kind of an injunction to say that that there is a easier method by which one can approach the court and keep taking injunctions against these websites that keep popping up. I'll not get into too much details of that, but that was one successful thing that was carried out. The second thing that I'm aware about is the Maharashtra, what we call as MCDCU unit in Maharashtra, where the cyber cell in Maharashtra took a very, very aggressive approach with the industry, and there it was a PPP kind of a model where the industry participated in the endeavors of the police, the cyber police, in tracking down all the websites which are pirated websites, and been able to convince to get them blocked through the ISPs and the like. So that was a very interesting initiative that was taken, but much needs to be done in terms of either amendment to the Copyright Act or the Information Technology Act. There is a debate going on where does it fall, but a simpler administrative process, and Delhi High Court in fact has gone about and commented on this, that it is not possible for the IP owners or the platforms to keep taking injunctive orders from the court. So there has to be a simpler administrative mechanism available to block these websites, and that will not only help the digital industry or digital platforms, but the entire industry as a whole. So these are the 2-3 initiatives, but really what is required today is an amendment to give this simpler, clean mechanism. And we will be making recommendations in that regard to some of the regulatory authorities as well.
Okay, that's perfect. I'm conscious that we just have 2 or 3 minutes, but Siddharth, I know you've been a part of in-house team. Maybe your quick thoughts on this piracy issue.
Sure, thank you, Ranjana. Well, for any digital business, IP is a major asset, and protecting it is quite important. And it is a big concern for the business, so therefore it is a big concern for in-house legal teams as well. Especially in an environment where content may be available for free, but it is still ad supported, and especially where ads are paid for on a cost per view basis, acting against piracy becomes important. But there are some very tough calls that have to be taken in-house, because you have limited resources and you must decide where to spend them. So you cannot go after everything that's available on the internet. You really have to take calls on what the big fish really are and try to get those domains blocked, by getting court orders. An interesting new issue that we also faced was sports being made available on these social media live tools, where you don't really need to do anything more than point your phone camera at a television and make it available to your users. In that case, it sort of becomes important to work with these social media platforms on a relationship basis and try to figure what can be done about this. But definitely, it is a big issue that needs to be solved for in ways that we really cannot, we really have to deal with in a technological manner as opposed to a legal manner.
Fantastic. Thanks so much for those insights, Siddharth. And I'm extremely proud of our panel. We made it dot in time at 10 p.m., not a minute extra. But thank you very much. I know we're completely out of time for questions. What the panel did endeavor to do was take a couple of the questions as we moved along, although I did not call out, or they did not call out the questions necessarily. We're always going to have tremendous number of questions, but please feel free to write to us in case your questions have not been answered, and we'll be more than happy to address them separately for you. And with that, thank you very much. We are not going to keep you away from your dinner. I'm going to hand this back to Khaled, who do the job of taking over from here. Khaled, over to you, please.
Thank you so much, Ranjana. I would also like to inform our participants about our upcoming webinars, which are arranged for tomorrow. So at tomorrow at 12, we have Founders One-on-One. That's Legal and Tax Issue Series. In collaboration with TIE and IAN, Startup Policies, Tax Exemptions and Angel Tax. It will be at 12, and at 3 p.m. we will have Is It Time to Join the Indian Gaming Industry Hustle? Unraveling the Legal Juggernauts and Opportunities. So I request, if you would like to register for it, please go to our LinkedIn as well as website. We have more details on it. I again want to thank all of our panelists. Thank you so much, Gigi, Aarushi, Ranjana, Siddhartha. You are amazing tonight. And that ends the session. You may now disconnect the lines. Thank you so much.